I think that we should begin our meeting. And I'll start by introducing our panel. First of all, let me tell you the purpose of our visit, which I'm sure that you know. We are appointed the committee by the Law Association Committee, and our task is to deal with judicial appointments. The members of the committee are Dr. Terence Farrell, economist and attorney at law, former deputy governor of the Central Bank of Trinidad and Tobago; Mr. David Abdullah, economist and former vice president of the Oilfield Workers Trade Union; Mr. Rajiv Prasad, attorney at law and vice president of the Law Association of Trinidad and Tobago, who regretfully isn't here; Ms. Tracy Robinson, senior lecturer in constitutional law, University of West Indies, Mona campus; Ms. Vanessa Gopal, attorney at law; and Mr. Rishi Das, attorney at law. And I am Desiree Bernard, former Chancellor and Chief Justice of the Judiciary of Guyana and recently retired from the Caribbean Court of Justice. It's indeed a pleasure to be here in San Fernando, and I look forward to us having a very interesting meeting. Just for the record, I just let you know what our terms of reference are. It's to examine the constitutional and other arrangements pertaining to the selection and appointment of judges of the High Court and the Court of Appeal, and to make recommendations including changes to the Constitution and our current practices and our procedures of selection criteria, with a view to ensuring due process, transparency, and accountability, whilst maintaining the dignity of judicial officers and the independence of the judiciary, to consult with stakeholders and members of the public, as we are doing here now, and to receive and consider their written and oral submissions. And lastly, to report to the Council of the Law Association within 3 months. That time has been extended, or such further period as the Council may allow. So with those few words of introduction, I think I'll throw the floor open to you, because we are here to hear what you have to say within the confines of our terms of reference. And we hope that we can answer any questions which may be bothering you. Thank you very much. It's informal, so let's get the ball rolling. Thank you. Okay. Yeah, there's the microphone there. Thank you very much.
Testing, one, two.
Introduce yourself.
Yes.
And your portfolio before we start.
Yes. My name is Lennox Sankasing. I'm an attorney at law.
Okay. Yes.
Firstly, Madam Chairman and members of the Commission. Firstly, I would like to commend and congratulate the Law Association for setting up this committee to examine this matter that is stated here today. It is a bit unusual in the sense that, as far as I can recall, this is the first time that there is a consultation in a private body, although one may say it's sort of quasi-governmental because you have certain public functions, but it's essentially a private body. And I've never heard of a public consultation being held by a private body like this before. So this is the first. And I hope we see many of these things in the future. So this is a really bold and creative step. And as I mentioned to Dr. Farrell earlier, I think this is a step in diversification, actually. Secondly, we have had a lot of consultations in the recent past in the sense that well, this year, for instance, the new local government reform bill, we have had 14 public consultations, and even before that, the last administration had 14 consultations on their local government before that. And even before that, Mr. Cecil Manning had 14 consultations also. So consultations are not something new in this society. But what would be totally new is if this committee can place a different emphasis and provide a different format and have a different result and enhance the governance of the system by having a qualitatively different consultation. And by this I mean that if your consultation would have, that there would be something meaningful coming out of it, even though you don't make any great recommendations or nothing really substantial come out of it, but it must be meaningful in the sense that people who contribute and the society must be aware of what happened, what was said, and most importantly, what was the response or what is the response of the panel to the recommendations. Because what we have had so far in the many, many consultations is that people come and they talk, and at the end of the day, no one knows exactly what is accepted, what is rejected, and that sort of thing. So it would be nice to have some meaningful responses to this. And the people who have contributed would feel that, I have gone there and I've made a contribution, and they're hearing me because here's publicized in the newspaper that I said this, and they didn't accept this part, but they accepted that part, and so on. That would be meaningful. So that's one. This matter will also widen the whole scope of the processes that we are talking about. For example, some of you may be aware that about how industrial court judges are appointed. You know that the cabinet makes that decision. In fact, industrial court judges is notorious, I think, that many of them, I would dare to say, are really allies of political organizations more than anything else. That's how industrial court judges are appointed. They are really political appointments. That's another aspect, and that should be, I know it's not part of your terms of reference in that sense, but I believe it could be part of your wider terms of reference, actually, if you look at it from a wider perspective. And then if you go a little bit wider than that, you will see that many, many appointments are made where a name is just thrown out and say, well, this person is now the ombudsman, This person is now the head of this and the head of that and so on. And you will hardly ever see where, if the president is appointing, where the president will have an advertisement out and says that the president has to appoint independent senators, for example. Under the Constitution, he has to appoint 9 independent senators. Expressions of interest are invited, or nominations are invited. But suddenly you see 9 people appointed, and you're not sure exactly how the president went about choosing those 9 people. Were they the best possible 9 people that could have been chosen in these circumstances? And the simple point I'm making here is that this kind of clandestine way in which the whole system is set up and how it operates is part of the temperament and existing culture of the society that prevails, and even by the persons who ought to know better, it continues. And I think what we see, what is happening today with this committee is perhaps a step in breaking that down. And I hope it breaks down quickly. And I know David will be very much interested in pushing that line. He's a man from the people, and he will certainly want to do something about that. I had a few points listed here, but I can't find them now. Sorry. Yes. The appointment of judges and so on, well, I see well, every time I look at the newspapers and I see the reports with respect to your meetings, and I see points being raised, and many of those points I agree. Simple things like, let's take the chief, you have a committee of 4 or 5 people, sometimes 4 sit, the Judicial and Legal Service Commission, and the Chief Justice chairs the meeting. So 4 other people will be there, and the Chief Justice is the chairman, and he has to work with the people who are appointed. And the other 4 people sitting around the table, they all know that the Chief Justice is the man in charge here. He has to work with these people. He must know best who will be suited, who will not be suited, and that sort of thing, because he has to work with them. Even someone going up to the Court of Appeal, well, the Chief Justice will know the performance of that judge. Whatever he says, we'll be willing to go along with it, and so on. We have to stop that. We have to stop. That's definitely wrong. And one may even go so far as to say that there might be, in some cases, a conflict of interest and duty. Laymen say conflict of interest, but we know the proper expression is conflict of interest and duty, in the sense that the Chief Justice will have an interest in maybe promoting certain persons, but he has a duty to be fair. So that's where the conflict of interest and duty will come up.
Might I just interrupt you now?
Yeah, sure.
Are you saying then that the Chief Justice ought not to be the head of the commission, of the Legal Services Commission?
Well, maybe it depends on what the commission is doing. If the commission is choosing judges, I don't think he should be chairman of that panel or that group that will be choosing judges. It's possible that he may not be there at all, be there just for guidance, but certainly I don't think he should be chairman of it.
Of the commission, only if they're appointing judges? Because it's the Legal Services Commission.
Yes.
So
well, as it's presently structured, it's the Judicial and Legal Service Commission comprising 5 people.
Yeah.
And he's the chairman, he's the head.
Yeah.
So I'm saying that that system should be reformed in a way that that he should not really be head when you're choosing judges.
Yes, continue. Sorry.
There are these are the basic things that I really wanted to say. Fairly brief, but I think they are very important points. And this is about what I have to say so far.
Mr. Sankar, one of the earlier, one of the things we're considering is at what stage should there be publicity, if there should be, at the nomination stage or after there's a preliminary assessment of candidates or just before appointment. Do you have any thoughts on how the system could be opened up for public scrutiny, in the appointing of judges particularly?
No, I don't think I mentioned the word secrecy. I mentioned secrecy in terms of, like for instance, when the temporary senators are appointed, we don't know exactly how.
Yes.
Or that the industrial court judges, and so on. But in terms of the Judicial and Legal Service Commission, I know it's advertised when they need a judge. It's advertised. I know that for sure. And we have the criteria set out there in the Gazette. But certainly there should be some openness about it. But I really can't tell you exactly how that is going to work.
Okay, perhaps I misunderstood. I thought you were trying to draw an analogy, because what is advertised is the criteria, which is gazetted, but the actual candidates, it's only when they're appointed that it's sort of publicized.
That's right, and I think that was wrong. We should know in advance who are the candidates who are seeking nominations, and perhaps some people may even wish to write the commission on these people and say, well, listen, I think this is a very good appointment, or I don't think this is a good appointment, and say their reasons and so on. And in fact, we should go so far as to invite comments when the names of the candidates are publicized. And as you're on that point, could I just also add that this entire panel here and the topic that you're exploring is really part of the evolving process. As you know, in our societies, you could safely say that 99% of the population are already left out of the decision-making process. Even in local government, where local government should mean involvement of the people in decisions that involve their basic needs, you'll find that the vast majority of the people don't even know the names of their councillors. So it is, we operate a system where people are in various ways not part of the process, whether they're deliberately left out or whether the structural system historically, coming from colonialism and slavery and indentureship and so on, historically have been left out of the process. And we have not found a way how to reverse that process. We have not found a way. This is a good example of starting to reverse it. Well, this, as small as it may be, but it's a major step in that direction. So,
Thank you.
okay.
Yes. Give your name.
Rashad Khan, President of the Assembly of Southern Lawyers, Lawyer San Fernando. I want to thank you all from the Law Association for volunteering, first of all, of your time and service to the Law Association and to the public generally in this very important issue as to the appointment of judges both to the High Court and the Court of Appeal. So on behalf of the ASL, which is a body under the Law Association, we thank you for your service and for coming down to San Fernando. I want to start with first examining the question that got us here, which is whether the current system that we have in the appointment of judges, both to the High Court and to the Court of Appeal, is adequate. And the question of adequacy relates to whether it is adequate, for the present stage of our Republican state. The starting point must always be for this question as to what are the constitutional arrangements that allow for the process for the appointments to the bench, both High and the Court of Appeal. I would submit that for where we are as a developing state, the arrangements, the current arrangements, are in fact inadequate. That can be seen from the disquiet, not just from the public, but from the members of the Law Association and the judiciary, the bench itself, over a period of time, where we have now come to the point where judges are openly expressing their disquiet about the constitutional arrangements for the appointment of judges. And this is what has brought us here, that disquiet. So we must look at what these constitutional arrangements are. And the Constitution starts from the premise that the judges are appointed by the President on the advice of the Judicial and Legal Services Commission. So the President himself has no real function, as we have seen in the public domain that played out recently. The Judicial and Legal Service Commission interviews and recommends and appoints. Where we have difficulty, I think, is with the secrecy or shroud, or the perceived shroud of secrecy in the process of appointment. And that process, to my mind, must always have an objective component and a subjective component. The objective component must always be known to all persons who qualify to apply, and for all persons who are served by the judiciary. Because it's not only the persons who can apply to be judges who must know. It must be that all and sundry, the public must know who are qualified to be judges and the process to which they can apply. The current provisions in the Gazette of April 2000, I believe, April 13, 2000, in my mind, is more of an exception than a rule. There is more in the exceptions. It is to be advertised, but anybody could still apply. And there are provisions here, but they are so wide that the Judicial and Legal Service Commission is not bound really and truly by what the provisions of the Gazette is. So what that leads to invariably is when someone is appointed, and we only know, and I'll come to that, when the appointment on the eve of the swearing in, most times, nobody knows what has happened. We have seen an advertisement in the paper, but we don't know who applied. We don't know when they were interviewed, unless you knew an applicant and there's rumor in the corridors of the court. You don't know the process by which they were interviewed. You don't know if the process that was used for this batch of applicants was the same that was used for the last batch of applicants. And we only know these things because of people who applied. And they may have applied in 2014 and went through one process, and applied in 2016 and went through a different process. So we know the process changed, but nobody knows how, by whom, or why. And that is the shroud of secrecy. And I say a perceived shroud of secrecy because I don't mean to put any negative or spin to that and say that there was any malfeasance anywhere in the process. But there is a perceived shroud of secrecy in the way this occurs. To my mind, that process must be a fixed and stagnant process. If there is to be advertisements, there is to be advertisements. If there is to be an exception to the advertisements, there must be a process in which there is fairness, in which applicants can be invited. And now, that is where the gray comes in. Because we have all, as lawyers, have heard stories of X and Y being invited to apply. If there is an advertisement, X and Y can still be entitled, it can be invited to apply. Just they apply within the prescribed manner in the advertisement as gazetted in a new form. There is no reason whereby somebody will be invited to apply outside of the time in the advertisement, or maybe on the eve of the interviews, because we all know that is improper in public functions. In a public company, in a state company, you can't do that. You can't have an interview process for a president of a state company and then say, well, let us invite X, Y, and Z to apply for the president of the state company, and on the eve of the advertisement, bump a name in. I don't know that to be proper. And that is one of the questions we have to ask. As a maturing society, whether that power, whether it lies in the judicial, legal, and the JLSC or the Chief Justice, to invite applicants outside of the advertisement process or outside of an established objective process, and I would prefer to use those words, established objective process known to all, to invite people outside of that process to be interviewed. And then the question on the interview itself. I don't know if the more senior lawyers here are familiar with how that process operates. I see in the Gazette there are a number of criteria put there, but they aren't weighted in any form or fashion. And I don't know how that applies in the interview process itself. And that alone tells you that something is wrong with that process. If no one could put their hand and say, well, how does the JLSC apply these provisions of professional competence, integrity, temperament, and experiences, and all the things that flow underneath there? How is that weighted? How is that applied to a lawyer who is practicing family as opposed to one practicing criminal law? How is that weighted against a senior counsel who may apply versus a different person? How is reputation and relationship in Trinidad and Tobago apply in this as compared to professional competence alone and length of experience? Because this is an open consultation, we all hear it. Reputation and connection is more important in the appointment of a judge than competence and years of experience. I'm not saying again that that is correct, but that is the perception in the corridors of the court. And why? Because we only know about the appointment of a judge on the eve before it happens. We don't know what has happened before. And we know, because we are a small community, that that particular person went to the same high school with this particular person, and they all go, and I say this with no disrespect to anyone, they go to the same church or temple or mosque or whatever it may be. And again, I'm not saying that those things are true, but those are the discussions that take place. And in a subjective process, in a process where exceptions are more than the rule, those are the things, those are the conversations that happen. And as we mature further, those are conversations that are going to become, from little bumps on the surface of our nation, to become sores, and then they are going to lead to a democratic rot. And we already see signs of that occurring, because there is a distrust brewing between the public, the judiciary, the lawyers, and private sector. And once that starts to occur, and you start to hear disquiet about the appointment, not the functioning of judges, and how they rule, but the appointment of judges, well, then we are in trouble. Now, well, one of the things I want to address is the subjective criteria. The subjective criteria will obviously have to be the applicants themselves and how they apply. One of the things that a colleague of mine raised, and which I agree, is how do we attract more senior members of the bar to the bench? I don't know the answer to that question, and that's why I'm here and you all are there. But I raise it to say that it is a question that we have to ask. When last has a senior counsel applied? When last has a lawyer of 25, 30, 40 years experience applied and been appointed? I can't remember. And those are the questions we have to ask. Why aren't the senior members? Why aren't those people who we recognize as being the most talented are not on the bench? On the question that I was asked by Mr. Das, the other presenter, is one of the issues I wanted to raise, was the knowledge, the transparency issue. In my view, it can come at 2 points. Either, certainly not at the application point, but there must be a shortlisting process. And on that point, I wish to say this, which is another point of disquiet. It must be that in a modern society, if I apply for a position and I'm not shortlisted, I can be informed and I can be given a reason for me not being shortlisted. It cannot be that I find out that I don't qualify when the person is being appointed, because I don't even know when the advertisement, when the interviews took place. So I only know I didn't get through when they're appointing somebody else. So persons who apply must be written to and given a reason. And if we know what the criteria is, so for example, if somebody who's 35 applies, member, you didn't qualify because you didn't meet the criteria and so and so. Or if you're, for whatever reason. Those who are shortlisted, the advertisement could come either then, that these are the shortlisted members. There should be a period of at least 28 days in which members of the public, the law association, other interested parties who can qualify, but certainly anyone can write to the Judicial and Legal Service Commission or to other such bodies deemed appropriate to either voice their disquiet about that person, to raise an issue either on integrity, competence, or any of the other issues, paramount experience. And those can then be used, and they can be armed with the interviewing body, could then put those issues to that person. And the body could then have a full picture of the issues that may arise.
Could I ask you to wind up, because we
certainly. The other aspect is, the other time the advertisement can come is after the interview process and the person is chosen. Then that name could be put into the public domain, but the appointment does not occur until a 28-day period expires, and those letters of either recommendation, because positive letters can be written as well, or the complaints are made. So I think, in my view, my submission is it comes at the latter period after the person is chosen. I know there's the issue of people that don't want their names out there, but if you choose to go up for this position in the judiciary, you should be able to stand the scrutiny. Every member of parliament who goes up on the other arm of the state stands the scrutiny of the public. There's no reason for a judicial officer to not stand the scrutiny of the public as well.
Thank you.
You're welcome.
Much. Yes. We have.
Yes, good evening. Peace, love, and justice to you, and welcome to San Fernando, to all the panelists there. To the land of Archibald, everybody knows this is Archibald, the most famous, one of the most famous criminal lawyers here. He's obviously right now. But not, David is a San Fernando boy, so sort of. So welcome. My name is Alvin Bedo. And I jump in to change the tune a little bit. I like to say, I represent the plebeians, the man in the rum shop, and therefore have no more credentials than that. I saw the invitation, the public invitation to come to this. I said, okay, I'll come and learn a thing or two. And I try to gen up a little bit on it. And what I realize, in my view, is that to talk about naming, appointing judges and that sort of thing, that is a major constitutional thing. That's a major constitutional thing. Our judiciary is what they want, the separation of powers as one part of our government. And when you think about and we like to talk about the judiciary being the cornerstone and the rock for our system. So if you find you're talking about judges and so on, you are actually talking about changing or touching a whole major part of our constitution. Perhaps that is probably what we need to do. So that is not just, say, how you appoint judges. If you, all the newspaper reports of your consultations before tend to refer back to the question of Marseilles and so on, suggesting that this has come about because of that. It certainly came after that. So, one would ask, what was the whole purpose of having this? So that I say, this is a major, major thing. We probably have to look at it, have a different look. I think recently I've been seeing somewhere along the line somebody was talking about the whole judiciary, and I believe the point was that we need to overhaul the judiciary. I'm not sure where it came from, but I saw it in the last couple of weeks. Now, with all, I don't think in that kind of case, the rum shop could give much of a point in this thing. But there's a new twist to it. I noticed that the Chief Justice, in the swearing-in of the last 3 judges, who are all women, and they pointed out to the stream that they were in. When he appointed them, he made sure, probably with a little dig to the Law Association, to mention, but people are saying they don't know how judges are appointed. And I was highlighting the papers. And he seemed to be surprised that people don't know. So it's a good thing to hear these 2 lawyers just saying that a while ago. Because that is true. The Chief Justice said, well, he's surprised that people don't know. And he went on to say that, no, it is there, and he follows certain patterns, and the same thing about with the police, the Commissioner of Police, and they want to, that is talked about in psychometric things and so on and so on. But in fact, people do not know. And this is something that we could really, really think about. Now, he also made the point of, because the 3 persons who were appointed as judges all came from the magistracy. And he made a point, if I'm not mistaken, of how, they've recalibrated. He didn't use that word, but, something along the line. So you have people coming up through the system, through the magistracy, which probably is a very, very good thing, but we need to look at it. So he made that point, and I thought of the Law Association of how this is done. And I am saying that indeed, that is probably a very, very important point for me, for people at the rum shop level, not necessarily for the legal professional level. Because that is probably the area, we know that, where people interface with the whole justice system, the whole judicial system, is at the magistracy. You hear that kind of information be repeated every time, right? Thousands and thousands and thousands of cases at the magistracy, and how many at the High Court. So that is where the average person, not the average really, people get an interface with the law. And perhaps that is where we should be looking, and looking in terms of the whole stream, from magistracy going right up the line to the appeal court, because as the Chief Justice said, that is the area that is the line that is happening now. So
I think we will be looking at the appointment process throughout.
Yeah, well, okay, but all I'm saying is that what you send out or what you ask, didn't touch that because it seems to talk about the judges. And most people do not relate that in terms of the magistracy. So I think this is something, a way to look at. Now, if you think in terms of the judges, what I find, is that you think in terms of what are the qualities that one would presume, if the person has, would make him a good judge. At the lower level of the magistracy, what people they are concerned with, because what you're concerned with is the delivery of justice. That is what you're concerned with. All these qualities, what you want to know is that you get a fair trial, that you get justice, and you must be confident about the whole system. Long ago there used to be a saying, the Lima used to say, if you don't know jewelers, if you don't know jewelry, know your jewelers. And so that we have to be confident about the system, that it is fair, the system is working well, that is transparent. You look at people who are fair and so on. And some one or two qualities, and I had one that I thought of, people, a sense of humanity and humaneness about the judicial officers, and there's some experience. And one thing I thought, a sense of humor. I think a sense of humor, and as I said, a sense of humor, I just happened to come across a little quotation, and a sense of humor is the first aid to wisdom and philosophy. In trouble and adversity, it brings you smiling through stress and strife. It is the little things that count. The way a thing is said, the faint suspicion of a frown, the turning of the head, the tone of a voice that is kind or cold, the smile that is real or fake. And I go very much in terms of a sense of humor. And having said that, I want to follow up from Lennox. And I think I really want to commend the Law Association for doing this sort of thing. In fact, I always used to say, why the Law Association does not try to reach down to the public and talk about things and connect with us. So I think this is the first thing where you're trying to come down to us, because too often we have communication that is very, very horizontal. Lawyers talking among themselves. This is always the case here. But sorry if I break it and be a disruptor. But lawyers talk among themselves, but there's no reaching down. There's no vertical or even lateral communication. So I say yes, and perhaps you really need to take that into account and really do not, as Lennox suggested, do not make this like the other consultations. All those consultations that are non-consultations, they are all, to my mind, just public relations things that they come down to say. And nowadays, even the Prime Minister running down these consultations, no more than public relations town meetings. Thank you very much.
Thank you very much. Listen to you, so I expect we need to hear further from the members of the audience. Please, let us have your views.
Good afternoon. I'm Sean Rupnarayan. I'm an attorney at law.
Your microphone.
Sorry. You hearing me now?
Yes.
Right. I agree in large measure with a lot of the contribution from Rashad. Judges in Trinidad and Tobago are appointed, it seems, in secrecy. You don't ever find out. You have no opportunity to offer your views of the person, for whatever it may be worth, prior to their being appointed. You may know something about them through their professional conduct that may be useful to the body that is proposing to appoint them, that may be relevant. It may be an endorsement, or it may be a negative aspect. But the opportunity to comment, and it's not only confined to lawyers, it would be open to the general public, because they would have interacted with those same attorneys at law in a direct capacity as their customers, as the clients. And they may have the opportunity to say, well, listen, this particular attorney, I've had this particular experience with it, which may be something the Judicial Legal Service Commission would find helpful to inquire into. It would certainly allow for a greater level of confidence in the persons being appointed in the wider public, that they would have withstood the scrutiny of the public that they are going to be appointed to serve. Now, it may be feared that you may have sort of negative old talk without any real factual basis. But if that is the concern, again, it could be then received by the, having identified who the individuals who have applied are, the Commission invites representations from the, or views of the citizenry, and take it into account in making the decision. An equally important component of that is that reasons must be supplied if a particular individual then is not selected. Because if you're not going to be selected on the basis, for instance, of something someone has said, then certainly you must be allowed the opportunity to challenge it. So it must be the provision of reasons. I think is one of the biggest drawbacks of our current system, and one of the greatest areas of disenchantment for prospective applicants, feeling perhaps that they may not get a fair shot, and two, feeling that, well, and that is justified by there being no provision of reasons as to why they may not have been selected, or where they may have fallen short, or again, although there are criteria set out, what is how exactly does the Commission measure interest in developing the law, for instance? So there are criteria set out without any objective markers as to how that is to be assessed. Is that to be assessed by you presenting some paper you've done, or what manner is it to be measured? That you display mature and objective judgment. In an interview process, I don't know how that is to be weighted. So even the criteria, although they sound good on paper, they don't really have any substance in terms of where someone can actually identify what is required and what is being measured and how it is to be assessed, so that you can actively then try to fulfill the criteria and therefore meet the mandate that is set out, which is very, very good, but it's just sort of nebulous. So those are my brief contributions to the committee. Thank you.
Could I answer? Yeah, sorry, could I just challenge you on 2 or 3 points? It's interesting to hear that applicants should be given a reason why they were not even shortlisted. But of course, employers don't do that generally. So normally when you see an advertisement in the newspaper, you will see unsuitable applications will not be acknowledged. Now, I'm not saying that is the correct practice, but it's interesting that attorneys are suggesting that be the standard for judges, but it is not generally the standard for employment in the country. Secondly, and I think Mr. Khan made the point, but I'll tie it in with what you said about persons, even after they're interviewed, because I have sat on interviewing panels and so on, interviewing for chief financial officer, CEO, whatever, and they're generally, this is when people have then been shortlisted in state bodies and so on. Persons are not generally told afterwards why they were not given the job. There's normally a polite letter, thank you very much, and so on, but you're not generally told why you were not taken on for the job. So the third issue that I wanted to raise, just from the practice of how hiring is done, I'm not saying that is the ideal, I'm just saying what happens generally in the country. The third issue relates to shortlisting of persons who have not necessarily applied in the process, because what sometimes happens is that you go out by way of a public advertisement, you begin your selection process, including interviews and so on, and then you don't think that any of those applicants in fact fit the bill, at which point in time there's a second round of trying to fill the vacant positions by way of headhunting. And it's well known at senior positions, I'm not talking about junior positions, but senior positions in companies, that the employer may then, or the firm, company, whatever, statutory body, may then hire a HR company who would then be given a mandate to headhunt. And headhunting then takes place, which of course is quite outside of an application process. So I just wanted to put that out there, because when you are making statements about this doesn't apply elsewhere, it in fact does apply elsewhere. So we just need to be sure that we are comparing apples with apples. Yeah. So I just want to make that point. And I'm also thinking that we ought. I agree that there's need for transparency. I'm not challenging that at all, but I do think that we also have to recognize that that fairness has to apply not only for people who are attorneys or aspiring judges, but fairness really needs to apply in all employment practices in the country. And it would be very good for attorneys to take that up and not only represent employers against trade unions. But that's just my little aside.
I am in full support, Mr. Abdullah, as to the provision of reasons across the board. I think it is where, as Rashad had said, as our society matures, that is what is required, especially perhaps in small societies where very often you end up with rumors of, well, it's because of who know whom that you've been appointed or you've been bypassed. And the only way objectively to get past that and to allow for objective challenge and review is the provision of reasons. There is no other way. So it may be different in the context of the wider job market, but I think it is, of course, in the best interest across the board that reason be provided for any decision you take with respect to any individuals, because it promotes the individual. The individual is allowed to understand where they may have fallen short and how they may better themselves. I don't know if that has...
maybe I can
agree
ask,
with you.
there are a couple of questions I wanted to address, I think partly to you and maybe perhaps to Mr. Khan as well. You mentioned the idea that after the shortlist has been generated, in terms of your process, that there should be a period in which
Comments, perhaps.
public and attorneys should have the opportunity to comment either favorably or unfavorably on the candidate. My question is, if something egregious is known about an attorney, would that matter not have been flagged to the disciplinary committee of the Law Association prior?
Not necessarily.
So that, and I want to leave that there. And you also made the important point about our society and mauvais in our society, that people may malign somebody without any basis, so that you may run the risk of somebody being put in a position of having to respond to really mauvais langue and old talk without knowing who has generated that talk. And I just want to flag that as a possible area of concern. I just want to point out that in the context, for example, of the Canadian process for the selection of well, I think certainly for the Chief Justice of Canada, all of the applicants for the position, which by the way is decided by the Prime Minister, right, of Canada, all of the applicants are subjected to the privacy provisions, which is to say that they are told that when you apply for the position of Chief Justice of Canada, that the information that you provide may be given to certain bodies for the purpose of supporting the application, which would include, for example, the security agencies. We know that in our case, we have been told, we haven't been given that in writing as yet, but we know from our conversations with the JLSC that at some point in the process, the JLSC does ask the police service through the special branch to do an investigation of the individual and presumably look for a criminal record and so on. In Canada, there is this provision that protects the privacy of the applicant, so that even in Canada, they don't know who are the people who have applied. And I think that is part of the issue that we are grappling with here in terms of how do we deal with this issue of transparency versus protecting the confidentiality and the privacy of the person. One of the issues that has been raised with us, for example, is that if you are in chambers with an attorney and you are the senior and he is junior to you, and you both apply unknown to each other, and he gets elected, right, and not you, whether situations like that then create or may create problems within the profession. So I just want to put out some of those issues for your comment.
The first comment I'll respond to, I agree, so that you may have mauvais langue, and I think one way to insulate that, it doesn't have to be open, that the responses that the Commission gets can be within a time frame, and it's to the Commission. So the Commission's deliberations are private and they're confidential, but the Commission has the benefit of receiving information, having put it out. So the mauvais langue doesn't necessarily spread beyond the Commission itself. And I think if you put yourself into public office, especially as a judge in any country, that is a very public position that you would be expected to conduct yourself with a level of propriety that is inherent in the job. And so I think weighing it, it is better to have it than not have it. And one way to limit the risk of negative publicity would be the information confined to the Commission, which may be an expanded Commission, by the way. But I don't know if that.
Could you then elaborate on that point about the expanded Commission for you?
Right. So, as we've seen in the constitutional arrangements, it's essentially 5 members, and they're all legally trained, bar one who may be the the public service ex officio. And if we having judges who are appointed over Trinidad and Tobago, different society sectors ought to be involved, not necessarily, again, with a predominant position, but to represent views, and we don't have a situation where, for example, in the industrial court, there seems to be a perception that the court is skewed one way or the other. Having representation that may be broader based in the selection of judges may help go towards alleviating some of those concerns. I also have no difficulty, as I forgot to mention, Mr. Abdullah raised the point that it is possible to headhunt beyond the parameters of an application. So you may have a candidate and you may be aware, a member of the commission may be aware that a particular person may perhaps be a good candidate, but you can encourage him to apply. It doesn't, I don't think, within the framework of the time when applications are made, and say, listen, I think you'd be an excellent candidate, why don't you apply? And I don't see that we should move towards then having selected individuals targeted outside of the time frame. If there's a need, if you don't attract candidates in the first round and you want to put it out again, then you go and say, listen, Mr. X, I think you should perhaps apply. Since you and I are friends, I wouldn't go and sit on the commission. I will indicate that, and you can go through the process. I think that perhaps might be the better approach. Thank you to the committee.
If I could just say one thing. Sorry, let me not cut into your quote. Just to link back to what David was saying about the giving of reasons not being part of the norm in the country for employees generally. And it's something that Rishad said as well. My own understanding is that under the Judicial Review Act, you have a right to request reasons. Now, I don't know if any candidates who were not selected and who may have applied, I don't know if they actually did request reasons and what the outcome would be. But it would seem to me that as a public authority, that general duty would apply. It would just mean that you would have to request it, I suppose. So,
right.
I take the point about the evolving standards of administrative.
And it should be provided in due course, although there's a remedy, as you point out.
Yeah.
Thank you.
Good evening, members, illustrious members of the panel. This is the last opportunity, so I had to be here, even though I should really have been in Port of Spain or perhaps in Chaguanas. Thank you so very much. I was here not too long ago, giving the distinguished lecture. So again, I'm here in this hall. The judiciary is one of the cornerstones of the modern democratic state. And the way judicial officers are appointed has been an issue in many countries in the Commonwealth for a number of years. I quote here from Judicial Appointment Commissions, a model clause for constitutions. I assume that the panel is aware of this document. The Commonwealth Lawyers Association, the Commonwealth Legal Education Association, and the Commonwealth Magistrates and Judges Association came together and produced this document. It dealt in a large part with who should comprise the selection panel. To a large extent, it follows what we have now, but it diverges from our system in that it includes, or it suggests that what should be included, or who should be included, are also law teachers. I'm not standing here as a law teacher, although I'm one, I'm just saying that is one of the persons. It also recommended that there should be about 5 lay persons on the panel. And perhaps one can consider in this exercise reconfiguring the panel that chooses the judges. I also looked at another document, Criteria for Judicial Appointment and Merit by Barbara Hamilton. And she is the law faculty in University in Queensland, or she was at some point, and she made some very, very valid points about what do you mean really, criteria for judicial appointment and merit? What do you mean by merit? And I'm glad that you provided us with documents here this afternoon, because I'd never seen it before. And it shows that you're looking at professional competence, integrity, temperament, experience, and there are quite a few criteria under each head. Now, I listened to my friend just now. I don't know his name, but I call him my friend. I assume he's a lawyer. He's dressed like one. Maybe an imposter, but I believe he is a lawyer. Hope he wasn't one of my students in whom I have forgotten. Were you, sir? You were my, I am so sorry. Well, after being in legal education for over 25 years, I've taught most of the lawyers. And I tell those in cabinet I take no responsibility for them. Now, one of the points that Hamilton made is the necessity for the judiciary to be representative. And she says it's not just a question of adding more women to the mix, but being representative of the society. And when we look at the judiciary today, can we really say that the judiciary is representative of all the groups and classes of the society? Or is it representative of one particular class or two particular classes? And the question that is in the subtext is not who you are or what you've achieved, but who's your daddy? Who's your mommy? Where did you go to school? So we need to look at all of those things. Now, my friend raised the issue of feedback. My dear, do you really want feedback? I think not, because some of the feedback can be so traumatic that you may wish that you never had any. And I will share my feedback this afternoon. It's never been shared publicly before, and I'm mindful of the code of ethics, which says quite clearly that an attorney at law should encourage respect for the court and the judges. But I still share my feedback, because I think when you are at an interview and you are being judged, you are also judging the panel. I can tell you that at the end of my interview for a temporary position, I judged the panel and found the panel wanting. Before I elaborate, I also want to tell you that I think your point of not knowing what people say about you is a very valid point. I have had the experience of a former president of the Law Association saying with utmost confidence that he had represented my brother and he wanted to know how he was behaving now. And he had represented a criminal matter. I said, that is impossible, sir. I have one brother who's never had any contact with the criminal law. He said, oh yes, your daddy brought me to him. I said, no. And again, on another occasion, that was at a cheese and wine and cheese, whichever one comes first. You know what I mean? So it was a public gathering. And so after it went on a second time, I called my brother and I said, you better visit this very senior counsel, maybe a QC even. And he walked into his office, and I was at home when the senior called me and said, do you know who's in my office? I said, no. He said, your brother is here. My brother walked into his office and said, do you know me, sir? He said, no. He said, but how could you have represented me? And he apologized to me after repeating it over the years. I don't know how many people he have reported that story to, that he knows my brother and he was in some activity. I myself have had the misfortune of having a judge make a comment that I had done something that was wrong. I had documentary evidence that he was wrong. I wrote him a long letter, and I was going to send it to him, And my very good and trusted mentor, Justice Telford Georges of revered memory, said, Hazel, don't do that. He's a judge. So people could be saying things about you that are so very wrong, and you don't know about it. So it's only fair. Now, you want feedback? All right. So I walk into an interview for a very temporary position as a family court judge, very temporary, 6 months, I believe, yes. So I said, maybe I should offer myself. In the circumstance where I had been offered appointments before and felt my first love is teaching, I didn't want to leave the law school. Even other places in the region, I refused. I said, let me take this for 6 months. I walk into the interview room, the first thing I hear, we have no US dollars here. All right? Because I was working in the Bahamas and my salary is equivalent $1 for $1 US dollars. How do you feel? You enter a room and that's the first thing that is said to you. This is a professional organization. You have a very impressive CV. Why you want to come here? I thought that having written and published extensively and spoken on every continent of the world in family law matters, and having been invited by chief justices of Hong Kong, Japan, Ireland, to come to their country and talk family law matters, all expenses paid, and talking everywhere, Sweden, Europe, Africa, you name it. Having sat with all of these judges, having had tea at the House of Lords, and have the respect of all of these people, that I would have been welcome. I was wrong. I was told, why don't stay outside and make a contribution? Why you want to leave your secure job? So therefore, I am not old enough to make a decision about my life career. I am being told as a child, stay outside my country and make your contribution. Where is the respect? But I've returned home and I'm making my contribution. And I'm saying we ought to look carefully about what we do, how we do it, what are the subtexts, what is operating in people's minds, what are we doing, what do we really want? Is the judiciary, as it's configured, representative of the society? Do people really understand sometimes, if they have never been poor, what it is like to be poor? If they've never been trained in certain things, how do you decide what kind of training you give your judiciary? All of this is bound up. What we do in juvenile justice, when we know that the judges and the magistrates do not even understand the principles that should govern them when they deal with child rights. When you have judges sitting who say, I don't agree with women who spirit away their children and the children, so therefore I'm going to cancel this maintenance order. And I said, my lord, maintenance is not predicated on access. They are two separate rights of the child. The convention rights, I am nothing but the convention. What do? I take the convention to his office. So there is a lot that needs to be done. And so far as the judiciary is concerned, we are not perfect. We are still trying to get there. But we must be honest about what we do, and the secrecy got to stop. Even though you think everything is properly delineated, there is a lot that goes on behind the scenes that we don't know about, that we need to know about. And I would say one thing, we have to stop being selective about the issues that excite us and deal with some issues that have been festering for a long time that we prefer not to touch because it is not on our agenda. Thank you.
Thank you for your contribution. Can I invite you, there's an email address on the documents. If there's any of those articles you wish to forward, feel free to send it forward. We would be happy to receive it for you.
Yes, I'm glad you said that because there's another document I've had for many years, but in Murphy's Law I couldn't find it. And it says, what you need in a judge, what you need most in a judge is a gentleman. And if perhaps he knows a little law, that's great.
Anybody else wanted to speak? Are there any other conclusions that you can hear? Please feel free. Yes,
the distinguished panel, my lady, and also my long not seen but female colleague, Ms. Gopal. Nice to have you here in San Fernando. Sherry and Rajkumar, attorney at law, I represent not only my views but also the views of some members of civil society. I will be providing written submissions to broaden what I'm just slightly touching on here on the subject matter, and to get directly to the provisions of the Constitution that I would like to identify. If we look at section 111(3), and if you all can look at it, a person shall not be appointed to any such office if the Prime Minister signifies to the Judicial and Legal Service Commission his objection to the appointment of that person to that office. Now, I do not want to get into any controversial debate about that section, but we are supposed to have a judiciary that is totally independent of all political interference. However, I am not lobbying for constitutional change or for constitutional experimentation or anything of the such. Actually, I support and endorse this provision whereby the relationship of the Prime Minister in conjunction with that of the Judicial and Legal Service Commission, it's constitutionally protected, and it also points out a bilateral duty. The bilateral duty of the Prime Minister to the JLSC, and likewise the JLSC to the Prime Minister. What I would like to say is that this section places an assumption that the Prime Minister should act rationally, fairly, unbiased, and of course, to coin the words of the former speaker, it places a duty and assumption that the Prime Minister would act in the best interest of all society and wider society and representative of perhaps all the views of society. However, this would mean, because Prime Ministers are political entities who would have won an election and have been elected to office, and the last power of veto, actually, which is a constitutionally protected veto, the Prime Minister actually has that. So if we are talking about the independence of the judiciary from being political or being unbiased, it would mean that a Prime Minister who does not have a legal background, he or she would have to be properly advised on the legal tenets of fairness, proportionality, rationality, and so forth. And it would mean that should a Prime Minister fall short in his duty, whereby maybe he may object to an appointment, or maybe he or she may approve of an appointment, and that appointment would fall short of what should be the criteria that is acceptable or set out for the proper selection of a judge. It would mean, in my view, that that Prime Minister, or even the JLSC, or however it would work, should be subject to JR, or probably a constitutional motion, or that decision can be struck down, because right now we live in the age of judicial review, constitutional motions being taken up in court, and also we live in the age of freedom of information. So what I'm saying is that I do not support any constitutional amendment of the section. I think that the section, if it is properly construed and interpreted, it would lend one to actually look at both the Prime Minister and the JLSC as being publicly responsible, even more than the Chief Justice, for the final selection of judges who appear on the bench. And this is something that we should look at going forward. Maybe it may signify that either the Prime Minister or the JLSC, whoever may compose the JLSC at the time, if they either object to an appointment or if they support an appointment, an appointment that may infringe on a person's right to actually become a judge, or conversely, if an appointment falls short of the criteria of being appointed to be a judge, it may be misconduct on the part of either the Prime Minister or the JLSC. But these are just preliminary thoughts which I would flesh out in further written submissions, which I would pass on to the committee. As I said, I would not like it to sound too controversial, but in the middle of doing some research today, I would just like to mention to the committee that Dr. Eric Williams, when he was the Premier of Trinidad and Tobago, he was the person that recommended the 4 service commissions that we have existing in this country. And those recommendations from Dr. Eric Williams while he was Premier, they were accepted by England. And when Dr. Eric Williams advocated the creation of the service commissions and the 4 arms of the service commissions, which includes the JLSE, his thinking was that there should be a society where every creed and race should find an equal place. And also his motivating thinking in doing so was the phrase that we now know, forged from the love of liberty. And in forming a free society, back in 1957, Dr. Eric Williams would have looked at liberty and put it in the context of service commissions, inclusive of the JLSC. Having said that, I would write the panel and flesh out further. Thanks.
Thank you very much.
Mr. Rajkumar, thanks very much for your contribution. I take your point about the fairness and the application of Section 111. I think, to be fair, that was the basis of the Feroza Ramjon Judicial Review, where they set aside a prime ministerial veto in relation to appointments of persons abroad. But I think, just to be clear, Section 111 doesn't apply to judges. It only applies to appointments by the JLSC of specified officers, being Solicitor General, Chief Parliamentary, DPP, so that the judicial appointments are not subject to a prime ministerial veto under this section. Thanks.
Yes, is there any other person who would like to contribute to the discussion? Anything from the panel? Oh.
Evening. My name is Kapil Dev Bihari. I'm a layperson. On my way in here, I got this package here, which included the Trinidad and Tobago Gazette. And when I look at some of the pages 291 onwards, I don't know if you all have the package there, I see the heading probate and letters of administration and so on. And I must confess that some morbid thoughts went through my mind about the judiciary. I'm making 2 points there. It's meant to be a joke, which I didn't get any humor from. Any laughter from. And also, this is the second time I was at your Shogwana's consultation. And I can't understand why all these things, probate and is attached to these things. It reflects badly, I must say, on the Law Association.
Right. Mr. Bihari, yes. What should have been given out was just the first, well, really the page 288, which is a specific part of that gazette that pertains to the appointment of judges, so that the other pages of the particular issue of the gazette, which is volume 39, number 68, were copied, but really didn't need to be copied, so we wasted some paper there. Yes? Because the rest of it is not relevant at all to this discussion.
Okay,
Yeah.
I meant that is what kind of invoked this morbid thoughts in my mind. And I hope, anyhow, this is the last consultation. Yeah. Now, as I said, I came here as a layman, and I was saddened, though not surprised, to hear some of the reservations by attorneys about entities as the Judicial and Legal Services Commission and so on, how they are appointed. I get the impression that there is a significant political component in the appointment of these bodies, and these bodies many a time could go on for many years. The Judicial and Legal Services Commission, for instance, is appointed. It's 3 members, excepting the chairman and the chairman of the PSC, is appointed by the president after consultation with the prime minister and the leader of the opposition. I suspect that when the Constitution was drafted, it assumed that people who are given senior position, who are invested with trust, would act with integrity. I personally, I'm not a young man, and what I have been hearing and reading and seeing and experiencing is that trust really is a very volatile thing. And I wouldn't trust at all. Right? For instance, another point I wish to make here, and I'm not a politician, persons with inside information could probably will know better on this. I will say that the appointment of the Judicial and Legal Commission, now I know that the term of reference is the appointment of judges, but the reason why I'm mentioning the JLSC is because they're the ones who make the appointment of the judges. So this is the foundation upon which the appointment of judges rests. So this is why I'm kind of belaboring the point on the JLSC. The appointment shall be made by the President in consultation with the Prime Minister and the Leader of the Opposition. I envisage when this was drafted that the drafters thought that the persons concerned, the Leader of the Opposition and the Prime Minister, the lady here mentioned, would act with integrity and do what is right. Unfortunately, politics always intervene, and that will never stop, I might add. This is why we have to keep revisiting the checks and balances, and it might be very bureaucratic. I know that is a bad word, bureaucracy, but the challenges that we are having here, it would seem that we have to continually look at these things as we proceed and dot the I's and cross the T's. If we do not do these things, we would be inviting trouble. We have rumblings going on right now in the judiciary. It's not good. It's reflecting badly in the country here and certainly internationally. Another question in passing I wish to mention here is the role of the President. I've been reading these couple of documents, and what role the president really plays. From my limited reading here, it seems that he acts on advice, he consults with the leader of the opposition and the prime minister, and many years ago, I might be wrong, in the time of, I believe, President Ellis Clark, where I think a definition was given to consultation, in summary meaning, well, I just have to talk to them. I don't have to take their advice and so on. And if I'm wrong, I would like to be corrected, please. And I suspect that we shouldn't be fooled at all, I believe, that this consultation really is really the president listening to what the prime minister has to say and who the prime minister wants to appoint. Now, I might be terribly wrong, but those are my views. It'd be interesting to find out from people who have inside information whether or to what extent recommendations of the leader of the opposition in this exercise is really taken into account. I don't recall reading anything about any leader of the opposition saying, well, look, I appointed A, B, and C, you know, and the persons were not selected at all. I never heard that. Dealing with the president again, I was reading the oath of office, where a key word in the oath of office of the president is to defend the Constitution. I don't know to what extent the president stands up to the prime minister and says, no, I disagree with this, I don't like this, and I do like this. I know our current president, he gave us some very cryptic information about the powers he has and the power he didn't have and things like that. I don't know to what extent those powers he has brought to bear in defense of the Constitution. So, in winding up, I believe people have a lot of suspicions about these entities and the processes and so on. And we really need to address it. The price of liberty is eternal vigilance. Thank you.
Thank you. Somebody new?
Madam Chairperson, I have one small clarification to make, if you would permit it.
What?
In relation to my friend's comment, if you look at section 2 before section 3, the officers that are listed there, what I would like to point out to my friend, they all form part of the wider public service and constitutes the wider public service. But however, I would flesh out in my written submissions. Thanks.
Okay, thank you. Yes, somebody else is here.
Mr. Chairman, Sebastian Spanley, a man from the trench, more than like Abdullah, Mr. Abdullah, than a lawyer. The problem that we are dealing with is the appointment of judges. The real problem starts with the Constitution and the President of Trinidad and Tobago. What has happened is that the President makes statements, I'm looking for people, and I can't find them. So therefore, what I get, I put. And what he gets and what he puts have us in trouble today. So maybe we need to find a method to deal with the appointments of members of the Judicial and Legal Service Commission. I agree with my lecturer here that the base should be opened. It should be widened. The President must announce make it public that we are looking for persons to be appointed to the Judicial and Legal Service Commission, and invite persons to apply. From that, we hope we'll get the best coming in, and he can choose out of that if he requires. Also, we need that grouping to be wide, because the president is a political animal. He plays the politics all the time, and you need to negate him. And the way to negate his thinking or his movement is to have a wider sector from the society. For example, the numbers here are very few. Probably persons, you can expand it to NGOs, trade unions, chamber of commerce, and those things. And by so doing, we hope to have strong persons to make those decisions. As it stands, Mr. President, Madam Chairman, everybody sees the appointment of judges as a boy clubs playing their games. That's the perception outside there. And that kind of appointment, those kinds of appointment, have us in the problems we have in judicial today. The type of appointments that have made, we have the problems where you have gang warfare in the judiciary. One set fighting the other set, and that doesn't augur well for the country. And therefore, we must find a way to ensure that this doesn't happen. Also, in that regard, what you really need is that the Judicial and Legal Service Commission, when it is appointed, before they do that, they must have a policy position which is known to the public. When you look at this document here, you see some criteria here, which is really nebulous and worthless. It is so wide that any number could play. They must inform the public and the persons who wish to apply what are the main criteria. I also want to indicate that in their process of setting up policy position, I agree with my lecturer here. It must represent all peoples of every section of the country. When the present Chief Justice was appointed, I remember the then Chief Justice Sharma said, this judiciary must represent everybody in Trinidad and Tobago. Look, we even have somebody from Quite Tobago. But what have we seen in the past? We have seen that that system has changed. Has the policy been changed? Why is the Judicial and Legal Service Commission changing policy among themselves to get a desired result? For example, we must say, for example, a CJ shall not hold office for more than 5 to 7 years, so that if we make a mistake, you know, as they say, to remove a judge is like pulling out teeth. So if we cannot use Section 136, we must make sure that if we appoint a person and that turns out to be a bad decision, we will not labor under that for a very, very long time, to such a time so long that we could destroy the judiciary to a point that they cannot come back. Also, we need to probably look at a judge, get mature judges on the bench, people who have experience, and you say they could stay there for about 7 to 10 years, so they could develop. But what we see, it would appear to me, they have not said it, that the aim is to get young persons on the bench. What you find happening is that after a while, those same young judges burn out. And therefore, we must have a constant change rather than having the same people going over and over and burning out. So that if we do so, I humbly feel that we can move forward. All the other points which I wanted to make have been made by the other members, but to say that we need to change the system. For example, there are magistrates, 43 female magistrates, 44 magistrates, 40 are female. You have appointments going on, recent appointments. What the appointments are? Female from magistracy. But before this, it would appear that the policy was not to choose magistrates. As I remember, in my last 35 years, you had Justice Gopi Singh, Justice Baird, and Justice Kenny Prasad. In that whole period, what has happened now? In the last 3 weeks, 4 weeks, magistrates, and they made disparaging remarks against magistrates for not appointing them, which I don't intend to. And what has happened? Has the Judicial and Legal Service Commission now changed policy without anybody knowing? Take, for example, the criminal judges. They all come, most of them, come from one office. People who have never practiced before, people who had fixed income, people, if they work or they didn't work, had a salary there. They didn't know how to deal with the outer world. And you see, they become judges, they're appointed judges. And then the people who fight against us are the people from the same office, like the judge. We are not casting aspersions at anybody, but the perception is that something is wrong. We ask the question, why nobody from the bar has been appointed in the recent past? Why? Is it because we have a row with the bar and the law association that I decided to deal with all the outside there and take only magistrates? What is taking place is creating confusion in the sight of the people and in minds of others. And therefore, when you ask them, how you didn't take anybody from the bar? None of them don't want to come. Totally untrue. Many people have applied and they haven't taken them. But when they didn't take them, they said they don't want to apply. So I think it's a very serious situation which must be dealt very quickly. All the points I say I wanted to make, my friends have made it, and therefore thank you very much.
Thank you for your contribution. Is there?
Okay, good evening, everyone. I am again just a layperson, a gentle observer.
Sorry, we didn't hear.
Can't hear?
Could you repeat?
I said good evening. I said I'm just a gentle observer, a layperson. My name is Kim DePisa. I listen to everything, and it's just shocking from a layperson perspective that we in this period of high knowledge sets an exchange amongst ourselves, and we refuse to examine the historical context that the Constitution was developed in, and then look at that and really wrestle with it for our time, and be brave enough to acknowledge that humans could learn a system and then exploit a system. And so we should be brave enough to develop mechanisms to control the human element. That's basically what I wanted to say.
Thank you. Well, I think we seem to have exhausted all the ideas, thoughts, suggestions coming out of tonight. Is there anybody who wants to? Yes. Okay, sorry. I think you also had said you want. Okay, you can.
Well, commendable Justice Desiree Bernard, Rajiv Prasad, Mr. Abdullah, the two other good people across there. I'm here to represent the people of Trinidad and Tobago in a very serious count. Firstly, we should ask why so little people from the public has been contributors of this public contribution.
Sorry, could you tell us your name? Sorry, just for the record.
Ramesh Naipal.
Ramesh, thank you very much.
Could you just repeat what you said earlier? I didn't quite hear.
Well, there's so few people there.
I represent
Yeah, I know that.
Okay.
You were saying that,
Okay.
developing that afterwards. Your last sentence. Go ahead.
What was I saying? Shall I continue? Yeah. It might make it more simple for me.
Okay, go ahead.
Thank you. But I should applaud the chair table for bringing this forum together. We are in a disastrous situation, lay people on the grounds. It's unfortunate we don't have much members of the public in none of these forums. by the population, it certainly expresses a strangulation of expression from the people on the grounds. And they are the one who has been affected most. These are real people with real situations. However, a couple of points that I put together dealing with the law and adults by the judges. After the penalty may have been served to the parents, what become of the 10 years and 12 years old children left behind in a house all alone in one of the squatting grounds? Are they sent to a school by those people who would be the predators? Are they going to be the victims to which would shed their victimization upon us? However, I have been involved in attending to situations like that, even right now. A constitution is what we are here to reflect upon. In my humble view, Trinidad and Tobago has never had a constitution. For a constitution is to be convened in its various constituencies by its constituents, to be written in a language to which is comprehensible to the persons who's writing the constitution. Such constitution must be upheld as the highest law in any land. It is the prescription which is written by the doctors of law, which is the people on the grounds, to be handed over to the authorities in the way in which we would like to have to be governed. And that is far from being in its presence. Mr. Wears has discovered in a constitution must be written not in rigid language, but in flexibility. To prove my point as to how many times this same constitution has been amended and still calling for amendment, which means something is terribly wrong with this constitution for so much of amendments continually with no inroads.
Actually, we are looking only, the constitution only relevant to the, in this appointment of the judges.
Thank you. However, it seems to be in many parts, even with the judiciary and the appointment of judges, to which we have observed that there seems to be tremendous default, where the selection has gone into the fist of the few rather than to getting guidance from the public out there who uses this constitution most. They happens to be the victims of the constitution as it is today. And it is real situation that is taking place where many is becoming very lawless, because whilst the cat is away, the mice is at play. So you're hearing many different deaths of all sorts taking place because there's a derailment in the social order. The order happens to be halted by order without much order. Hence the reason why we're in this state today. However, where are we going to go after this consultation? What it hopes to bring? And I'm seeing here that it takes persons who would like to make a contribution within 3 months, and after 3 months, what? Isn't that going to be much too long for in the crisis that we are in right now?
Well, actually, it means that the committee was originally given 3 months to submit a report. That has been extended because we have had to go all around the different places as we are here and get opinions and so on. And then that time has been extended now, I think, to January. I think. But whenever we hand in our report, it's up to the Law Association after then to disseminate it wherever it should go, to the public or whatever. So that is the position.
So therefore, what I am hearing is that the decision of all these consultation does not rest finally into the hands of this committee.
No, we have to submit a report on what has happened. We come to the conclusions, listing the conclusions and information that we got, and we send it back to the Law Association. So that's our report.
If it is possible that we can do with a lot less immunity from those in public office at the head levels, I think that would be some form in controlling the public heads so that things could not become so very tight, so very rigid, much more flexible, and it can be able to reach out to parties on all sides.
Right.
Thank you very kindly.
Okay, thank you.
Thank you.
Thank you, Madam Chair and the panel. Friends, I wish to speak in terms of de facto and de jure. De jure, and I look at page 288, and it's wonderful to see that we aspire. And then we end up with people who lose their sense of integrity. And these people seem to migrate to the very highest levels of responsibility in this country. To speak about law from the de facto angle, I have been lucky not to come anywhere near the agents who hold up the law. In the last 10 years, I've been so terrified sometimes, I have to blank out a part of my mind as I leave home and go to the grocery or the hardware. And when I get back, I go in and fortify myself and create a nice little prison for myself. And that's the way I spend my time. And I look at all of us, and I wonder when we are going to possibly get back to where we used to try to be good people. That, I am afraid, and I'm sad to say it, I don't feel too good about having to say it, because it makes me feel ill that I live in a place that's lost itself, and which has gone to a point where sometimes, in despair, I say we are at war with ourselves, this society. People going off in all directions, not even thinking, but jumping to conclusions. Now, an observation that came to me was, why has it taken us so long in a small country like this to react to what has been happening at the very highest level, at the judicial level with these judges? And I'm sad to hear that they come not out of the ranks of the legal fraternity, but up through the ranks of the magistrates. When I was a boy growing up, people who studied law and came back home, if they could not mount a practice where they could look after themselves and get enough money, they shifted into going and taking a place on the bench. So I don't want to take any more of your time, but I'd like you to take into consideration the question of where we as ordinary people stand. And I have no faith in what is emblazoned on police cars: serve and protect. When I see policemen, I try to go by the side, get out of the way, not look at them, let them pass. They are the arm of the law. And I see them as being insensitive brutes, thugs. That's the kind of country I live in. And I can talk. I have a little penny, and I'm not in the position of really poor people who don't understand the fancy language that we code law in. Sometimes I've wondered in the past, when I look at a piece of law, whereas, and then whereas, and whereas, and I say, what primitive kind of way of putting the law? It ain't even know English. We're living in the 16th century. Why don't we come of age And these are the challenges we face as a country. All of us. I'm not excusing myself. Thank you. Like a lot of people.
Well, I think we've had a very interesting... Somebody else. Somebody else. Would you like to speak? Could you? Yeah, well, you'll be the last.
My name is Faizul Ramjan of Faizabad. I got the wind of this meeting through an attorney who I work with in other matters, dealing with Petrotrin and land matters. And I felt what was being discussed was not only my recent legal attachment to the lawyer, but my business with family matters since 1981 that went before the judge. At that time, I wouldn't call the names of the judges, but there are 3 judges in particular with 3 matters that I felt needed to be addressed. Handwriting matters with fingerprint expert and decisions made on it, even though I had brought the handwriting expert from Canada, and I felt my matter was rest with the handwriting expert, and there was no need to bring another witness, but I lost the case. At that time, I felt I should appeal it, but my dad said, no, we're not taking it further, forget it, we'll already go through. Fine, so I followed that. I realized there was some issue with the judge, how it was settled. Actually, I left to go away for a trip with the Petrotrin, and I left my dad and my uncle to handle the matter. And when I came back, I found out there was some form of what you may call collusion. I wanted to appeal it, but my father didn't. That was in 1981. It went until 1994. And that's a long time of stress. 81 to 94 for property, family property. Recently, I had other matters with a judicial review case with my sister, one Firoza Ramjan versus the then Prime Minister Patrick Manning, which went before the Privy Council, so it had to go through the appeal judge at the High Court. So I had issues there also. I saw those things, I tried to raise it, but I'm not a lawyer, but other lawyers said you could take the matter further. And this all has to do with judgments, so we deal with judges on how judges make decisions. And in a recent matter, just a month ago, where I appeared in before the judge with my attorney to find out the matter was adjourned to next year, February. No notification to my attorney. So I went to the judicial office or the magistrate for the records to find out how the matter was adjourned, to find out that it was agreed by both parties, which is really the other party, and the judge. So I said, I need to know more, I need to challenge this. So I'm now in the process of getting the information to challenge the judge's decision. Again, no names being called. So these are the background to my suggestion for the appointment of a judge, which is the purpose of this consultation, to be appointed by the citizens of Trinidad and Tobago by the form of an election, whatever the process of the election. But that's one of the points. And the person wanting to become a judge should have at least 15 years experience in the legal practice. I'm also in all areas of law, civil, matrimonial, criminal, or otherwise. I always thought as a young person growing up and being in the courts that you become a judge after you were a lawyer, then you became a magistrate, and then it's like a promotion. But it doesn't work that way. So if you're going to be transparent and proactive to have the best judge for the best area of law, I think the citizens as a form of voting, but a minimum requirement for the person who wants to be the judge or has not been selected. So that's going to be discussed at a later time. I said 15 years. And the other thing is, when they're finished with being a judge and they retire, I think they have 10 years in which they could go into private practice. That needs to be looked at. I think a maximum of 5 years. In fact, I see certain attorneys at magistrate courts who are in their 90s, and I have a problem with that. But that's another issue. But the point is, magistrates also could be appointed in a similar election process. Because I have a lot of matters in the magistrate court with civil matters, traffic matters. I always challenge it. I have 9 times I've appeared for no headlights when I had 3 headlights. And the police officer said, twice you could challenge it. That was since the state of emergency in 2012. I was out at night. I had a permission to drive. And it was right in the station where I lived in Oropuch, South Oropuch. So the point is that these matters of the magistrate prolonging and keep adjourning when the police is not present. So I told the magistrate, this is the 9th time the police hasn't come. You're wasting my time and your time. And she asked me if I'm telling her how to do her job. So I said, my apologies, Your Honor. And then I left, and she adjourned the matter. So I turned around, and when I was going out of the court, excuse me, Your Honor, may I inquire your name, please? She said, ask them outside. I said, what do you mean, in the road? In a manner of tone of voice. And I hastened out of the court. Now, I saw talking to the prosecution, and I felt she was going to charge me for contempt of court, but I didn't know that clarification in the law, and I'm going to close now. I have to go to that court matter next 2 weeks, and it's before the magistrate. So in like manner, while it's a judicial appointment, I want this also be translated to the magistracy appointments, and also any other area. I thank you for your time.
Well, thank you very much. Well, this brings us to the end of our discussions, and I must say it has been a very fruitful and active discussion, and also the participants, the number of participants that we've had here has been very encouraging and very good for San Fernando. As I said, this is our last public discussion. We now have to settle down to collecting all the ideas and thoughts that were expressed, and then we shall file our report, handing our report to the Law Association. Again, thank you very much for your attendance, and I wish you a very good night. Thank you. Before you leave, if there were any other comments to be made from the panel? Nothing? Thank you very much.